Thank you all for joining us. My name is Jack Park. I'm the chair of the Professional Responsibility Legal Education Practice Group, and the focus of the practice group is on matters of bar activities, professional regulation, and the state of legal education. As part of what we do, we try to offer each year an ethics CLE that will help members of the Federalist Society get ethics credit with their state bars as it's required. If anybody's interested in working with us, please feel free to talk to me, and we'll be happy to give you something to do. What I'd like to do is now hand this off to Justice Barry Anderson, our moderator, Justice Anderson from the Minnesota Supreme Court.
So it's my privilege to moderate this panel. We have a distinguished panel of guests to discuss Rule 84G and the implications thereof. We've got a couple of housekeeping things to deal with. First, I want to say I'm grateful for this opportunity. Jack called and said they're looking for a moderator. They're looking for somebody with great charisma, speaking style, entertaining, etc. That guy's not available. I'm here. We'll do the best we can with the circumstances that are presented. The first thing I want to do is, I'm going to do three things. First, I want to present the question to you. Then I want to have a little discussion about how we're going to proceed. And then third, introduce the panel. And then I'm going to try to get out of the way since nobody here came to listen to me. So let me first talk about the question. And the panel had some input in how the question was going to be phrased, and I'm simply going to read it to you. Professional Responsibilities Rule 84G, using or abusing the licensing power of the administrative state. At its August 2016 meeting in San Francisco, the American Bar Association approved a major change to its rules of professional conduct that will affect all lawyers if adopted by their licensing states. New Rule 84G would make it professional misconduct for a lawyer to, open quote, harass or knowingly discriminate against persons on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, socioeconomic status, close quote. The new rule applies to, quote, conduct related to the practice of law, close quote, which represents an expansion from the present conduct performed in the course of representing a client, and new comment 3 defines conduct to include the operation and management of a law firm or law practice. The latter would include conduct at activities such as law firm dinners and events at which the lawyers were present because of their association with the law firm. The ABA rules are not self-executing. Any change must be adopted by states pursuant to their established procedures. While the Vermont Supreme Court adopted the rule and the New Jersey Bar Association recommended adopting the rule, the Montana legislature rejected a proposal, and so has the Supreme Court of South Carolina. Texas Attorney General Ken Paxton also wrote a letter that was harshly critical of the proposal. Our panel of experts will discuss the rule and its possible effects on the legal community. Secondly, the procedure that we're going to follow today is we're going to give each member of the panel 6 to 8 minutes or so. I'm the keeper of the time here, to make a presentation about their view on these issues. We're going to then have an exchange from and among and between the panel for 15 minutes or so, and then finally we'll get to questions. Let me say a word about the questions. We're inviting everybody to line up at the 2 microphones that are here. One there. When it comes time for questions, I would remind everyone that we're taking questions, not long statements, or this is not your opportunity to catalog the deficiencies of whatever it was you heard you didn't agree with. And I just want to remind everyone what we say on our website about the work of the Federalist Society, that we are providing a forum for legal experts of opposing views to interact with members of the legal profession, the judiciary, law students, and those in charge of public policy. So this is an opportunity for us to have a civil discussion about these issues. I'd like to move now to the introduction of our distinguished panel of guests. I'm going to introduce all 4, and then I'm going to get out of the way. I begin with, and the panel has agreed that it makes sense to begin with the first guest that I'm going to introduce you to, because she has been heavily involved in this process and knows a great deal of the backstory. Our first panelist will be Paulette Brown, who's a member of the Labor and Employment Practice Group of Locke Lord, LLP, and, relevant to our proceedings today, former president of the American Bar Association. She litigates in both federal and state courts. She has held a number of responsible positions, including in-house counsel to Fortune 500 companies, and also as a municipal court judge. We were visiting a little bit about that real-life experience. She has defended employers in cases involving discrimination on the basis of age, sex, marital status, and other protected classifications, received her Bachelor of Arts from Howard University and her JD from Seton Hall University School of Law. She's won a number of awards. We're not going to try to list them all, but the Defense Research Institute, the New Jersey State Bar Association, and the American Bar Association Commission on Women in the Profession have all honored her. We're delighted to have former President Brown of the ABA with us today. Also joining us is Ronald Rotunda, who serves as the Doy and D. Henley Chair and Distinguished Professor of Jurisprudence at Chapman University School of Law. I tried to hire a clerk of his, a student of his as a clerk a few years ago. We weren't able to get that done. Maybe we'll get another opportunity. He has clerked for Judge Mansfield of the United States Court of Appeals for the Second Circuit. He was, interestingly enough, Assistant Majority Counsel for the Watergate Committee. Some of you are old enough to remember. Those of you who aren't, go look it up. It was an interesting story. He has co-authored several works, including the most widely used course on legal ethics, Problems and Materials on Professional Responsibility. His work has been cited over 2,000 times by courts in this country and by foreign trial courts around the country. He's consulted with various new democracies in Eastern Europe and the former Soviet Union, and he too has a substantial background in the ABA, having chaired subcommittees and other functions. He is a graduate of Harvard College and Harvard Law School. Stephen Gillers is a professor of New York University School of Law, holds the ELU Root Chair. Did I do that? Did I mangle that?
Got it, you got it.
I got it, all right. It's, when you have a name like Anderson, you have to work on, names that are a little less Scandinavian. His research and writing focuses on the regulation of the legal profession. He's written extensively on legal and judicial ethics in law reviews and the popular press. He clerked in the Federal District Court in Portland, Oregon, and practiced law for 9 years in New York City before joining the New York University Law School faculty. He too has been active in ABA affairs as a member of the Multi-Jurisdictional Practice Commission, and the American Bar Foundation honored him with its Outstanding Scholar Award in 2015. His BA was from Brooklyn College, and his JD from the New York University Law School in 1968. Finally, but last but certainly not least, we're thrilled that Ken Paxton, the current Attorney General of the state of Texas, can join us today for this panel. As you know, the state of Texas has been involved in some litigation, and in recent years, his office has had at least 5 cases that have gone to the United States Supreme Court. They handle, of course, like all state attorney general offices, a wide variety of matters. Prior to being attorney general, he was a state senator representing Texas' 8th District, served 10 years in the Texas House of Representatives for the 70th District, graduated from Baylor University, earning both a Bachelor of Arts and an MBA there, and finally went on to earn his law degree from the University of Virginia School of Law. He was an attorney at Strasburg and Price for many years, and then in law practice himself. This is a distinguished panel. I'm thrilled that they are with us here today, and I begin our presentation today by inviting President Brown to step forward and share with us her remarks.
Thank you. Good morning. Thank you, Justice Anderson. It is really a privilege for me to be here this morning to speak to you about Model Rule 8.4G and what it means and how it came to be and how it would affect lawyers as we engage in the practice of law. So I am going to, and I have to first apologize because although I have slides, I always have difficulty following them. And so I may be ahead of a slide or behind a slide. I may forget to advance the slide and just go on talking. So I would ask that you bear with me on that. But what I wanted to do is to give you a little background on how we got to Rule 8.4G. And so there's some things that I think are important to know right as we start. So, you know, a lot of people have talked about, freedom of speech is violated or could be violated by 8.4. And, other people will go into detail about this, but there's certain things I want you to know. That freedom of speech remains intact, freedom of religion remains intact, freedom to join organizations remained intact, freedom to represent our clients in the most zealous manner remains intact, and importantly, the studies have indicated that there will not be an influx in new litigation as a result of this. So, what I ask of you is that all of us sometimes have blind spots. That, if it's like if you're driving an older car, not one of the newer ones that beep, beep, beep when somebody's in your blind spot. But a lot of us have blind spots, and sometimes we only see what we expect to see. So sometimes when new things are promulgated, we automatically default, and I'm guilty too, we automatically default to what we think should be there, and anything else may not be the right approach. So I'm asking you, to the extent possible, that recognizing that we all have blind spots, that we try to remove some of them right now. So we know what 8.4 is already dedicated to misconduct. And we already know that rules currently exist that talk about what attorneys can and cannot do with respect to the conduct of them as lawyers. But what we're not really here to talk about that today. We're here to talk about Amendment 8.4G, which states that which I don't have to repeat it because Justice Anderson already told you. But what I want to do is I want to highlight, you see what I mean? I didn't advance to the next slide. What I want to highlight to you is the fact that lawyers are not prohibited in any way to effectively represent their clients. So that means that if a client has an opposing view than you, if they believe in something that even you don't believe in, that does not preclude you from representing them, and that does not initiate a cause of action with regard to harassing or discrimination. And I think we also have to remember that when we talk about harassment and discrimination, we are talking about when one person harasses another person. We are not talking about engaging in public discourse or debate where we're talking about various issues and offering opinions. It is when we intentionally or we know that we are saying something bad about somebody or continuously bothering them maybe in a sexual way or something like that. And certainly there's been no shortage of news with regard to the harassment, particularly of women these days. So I think that this rule becomes even more critically important. So I want to talk to you a little bit about how we got to Rule 8.4G. So there have been attempts in the past, and Professor Gillis, I know, is going to talk about some of that. There have been attempts in the past to modify 8.4G, and they have not been successful. But there was really a great interest in providing an amendment to it. And so a formal request was made in 2014. And there was a lot of discussion concerning how 8.4 did not facially discuss discrimination and the impact of discrimination and how it impacts our profession and how we want to be perceived by the public. The public views us, unfortunately, not in the highest light, although I believe we are the most noble of all professions. And so what do we do about that? And so they went to a real expert who's the head of the disciplinary council of the state of Georgia. And in 2015, a determination was made that a serious look be given to whether there should be an amendment to 8.4 to add in the black letter law a provision that says that lawyers should not harass and discriminate. So it wasn't just like willy-nilly a decision was made. There were numerous public hearings that were held. There was a solicitation of a lot of written comments, and a lot of people really commented on this. There were constituent groups who expressed concerns based on religious grounds and a host of other things, and all of these things were considered. And so, but there was ultimately, at the end of the day, a desire for a better understanding of what it is that we wanted to be as a profession, and how we think that lawyers should conduct themselves while engaged in the practice of law. And so we did not really want, we want to know, when we do that, I think that sometimes it can be broadened to an access to justice issue and also a public perception of how people view us as lawyers. And so we want to make sure that we are held to a standard, basically, that the public believes that we should be held to. So there are a number of things that are not affected by the rule. As I mentioned before, lawyers can represent whoever they want to. They don't have to represent who they don't want to. They can, and in fact, I think it provides more of a protective edge than anything. So it protects people who want to exercise their freedom of religion, for example, so that if you see so a lawyer cannot harass somebody because they are of a particular religion. And I think that it has the opposite effect of people who believe that freedom of religion rights are infringed upon. So there are a number, and I'm probably running out of time, but there's just no limit to the ability to advocate on behalf of our clients. There's no ability not to engage in effective debate, and I know that I am really behind in my slides. So, and even like preemptory challenge, importantly, what happens is that the burden of proofs remains on the disciplinary prosecutor, and even beyond that, the disciplinary prosecutor has to make a determination that a claim should be brought. So there are still a number of protections that are in existence, and that we should not, under any circumstances, be afraid of 8.4G. We want all rules to be interpreted and applied equally to everyone. And it's really critical to ensure not only that there's access to justice, but that the public perceives that there's access to justice. And so I look forward to additional questions, but I thought I'd just give you a little bit of background on how this came to be. It's really important to the profession, and I think for the most part, none of us harass or discriminate, so there's really nothing to fear in this regard. Thank you very much.
Go ahead. Thank you, President Brown. Professor Rotunda, you're up.
All right, let's see if this works. My experience with computers are like dogs. They sense fear. All right, we're going to talk about this new ABA rule, and I think former ABA President Brown gave a very nice justification for a rule that the ABA did not pass. They passed another one. I just look at the language. There's me, for those who know me, and I'm the one to the left. All right. We live in a PC world. This is a verified complaint. Iowa State University, a state university, says that when you get admitted to the university, you have to give up your First Amendment rights. And that, for example, they say expressing opposition to same-sex marriage could be construed as harassment, just saying that. You can object to the Second Amendment, of course, but not to to gay marriage. They lost in court. But their lawyer, their general counsel, thought this was perfectly appropriate. And for those of you who aren't teaching in university, I live with this every day. Can the ABA be far behind? Of course, you have to be very PC. Prior to the change, there was a vague comment that said you shouldn't knowingly manifest bias and so on if it's prejudicial to the administration of justice. And then they said it wasn't a black letter rule, it's particularly vague. Then it said a trial court's finding that you dismissed a juror, a peremptory challenge, because you're racist, that's not enough to violate the rule. I think that's a hoot, you see. The judge finds out you're racist, and the ABA says, no, don't worry, that's not enough. And here's a new one, engage in conduct. And then they have the whole litany, plus they had a couple of others, gender identity, socioeconomic status. Height is not one of them. You can always make fun of me because of my height. And then it says it doesn't limit the ability of the lawyer to decline representation under Rule 1.16. I think, frankly, that's a misleading statement because 1.16 doesn't give you any right to decline. It says when you must decline, not in your discretion, but because you haven't gotten paid, or because continuing would involve you in a crime. And then it says doesn't preclude legitimate advocacy consistent with the rule. It doesn't say it doesn't preclude advocacy consistent with the rules or advice consistent. It's legitimate advocacy. What's illegitimate? You ask the bar disciplinary people. You won't find it in the rule. Discrimination based on verbal conduct. I think that's an oxymoron. I don't know what verbal conduct is. We're talking about all the news about people groping and so on. That's a crime. They ought to lock them up. That's an assault and battery. But verbal conduct, by the way, when people make their homophobic jokes and sexism and so on, we don't laugh at their jokes. We don't invite them to our house for dinner. We can shun them. We're talking about taking away their ability to practice law. The substantive law of anti-discrimination may guide, and from the history, the legislative history is very clear what they're saying. Just because you filed a lawsuit and the judge threw you out because you didn't state a cause of action in your complaint, that doesn't mean the bar is precluded from disciplining you. You can still be disciplined. What if the judge decided you exercise a peremptory challenge for racist reasons? Oh, well, that's different. Common force as it relates not just to representing clients, but interacting with witnesses, managing a law firm, participating in a bar association or social activities. But it's our right to engage in reverse discrimination, that is recruiting, hiring, and training, to get diverse employees. That's all right. Now, is the purpose of this rule to protect clients? You think that would be the purpose of disciplinary rule? No, says the ABA. We want a cultural shift in understanding. We're supposed to think differently. That's what the purpose of this rule is. Okay. Does it limit the ability of the lawyer to accept, decline, or withdraw? Rule 1.16 only governs when you may or must withdraw. There's no rule in the ABA model rules that said you can dismiss people, refuse to take them for any particular reason. Lawyer says, I won't represent a man drafting a palimony agreement for quasi-wife number 4. I don't believe, I think you're demeaning to women. That's discrimination based on marital status. You're refusing to take the case because you don't like the way he lives his life. Under the old rules, nothing banned that. Under the new rules, it seems to be unclear. New York opinion just came out. Says a lawyer won't accept a client suing the Mormon Church for gender identity. The New York opinion says, yeah, that can be a violation of the rules. That's discrimination because you don't have a right to refuse to represent people for any particular reason. It gets better. You won't represent a religious couple who objects to being forced to cater a gay wedding. The couple says, I don't mind selling them a biscuit or a cupcake as they come into to my bakery. I don't want to cater their wedding. I want to participate in it. Well, that's not nice of you, and the ABA says that would be a violation. That is, if you refuse to represent the religious couple, that's no violation. But you engage in racial discrimination in jury choosing, that's no violation. You won't hire the heterosexual messenger because he's heterosexual. That's no violation. So you're clear in all of that. What is this here? All right. But what about all the vagueness? Deborah Rohde said, trust us. I'm from the government and trust us. You will have to just trust us. Ms. Brown said that the disciplinary people, they're not going to do this too actively. You just should be careful. You have almost no rights when you're subject to discipline. You are judged by your peers, that is other lawyers, but unlike your peers, they tend to be very liberal. In addition, you don't have a public hearing. You don't have the right to subpoena witnesses. You're worried about them going after you because of your political beliefs, which what happened in the 1950s and 60s with the war protesters and so on. Why do we think that's not going to happen again today? you're on the water cooler, you say, I hate the idle rich. You're expressing discrimination based on socioeconomic status. Now, I know we all should be able to attack the upper 1%. But the ABA didn't write the rule that way. They said, no, any socioeconomic status. You would think that lawyers would be good in drafting legislation, and they'd be particularly good in drafting legislation about the practice of law. And this is what they came out with. You're just a short, fat, hillbilly Nazi. That's okay. That's always in good taste. The ABA in their report said that they went through a bunch of cases saying this is already a discipline in many other jurisdictions, and so it's not going to affect anything. I thought their list of cases, let's say, not candid. One of the examples, physical contact. Well, physical's always banned. You can't, an unconsented pinching, groping, that's not only vile, but it's a crime. And then you have some other cases about what happens right in the courtroom. Well, the judge has a lot of authority about what happens when he's in the courtroom. This goes far beyond verbal conduct. A UPS worker wore a hat that said, "Don't tread on me." The EEOC said that can be race discrimination. Now, I skipped one. Let me see if I go back here. All right, the Supreme Court said no. That was in 1999. The EEOC said in 2016, well, we think you're wrong. They don't cite that case, but they just ignore it. That's the EEOC. That's where you actually have hearings. The guy just wore a hat, and he thought, being a Revolutionary War buff, it had something to do with the Revolutionary War. No, turns out that's racist, and they have their hearing for that. At a panel discussion, Black Lives Matter, that's okay, right? All lives matter, many people think that's racist. Blue lives matter, many people think they're racist. Black olives matter for martinis, many people say, no, that's making light of something, that's wrong. You're at the St. Thomas More Society, that's a Catholic lay organization, and you can have an ethics, that's how the ethics opinion for the local bar will say that's not inclusive, because they'd like you to be a Catholic before you join. A bar can say, well, that's discipline. More significantly, a bunch of lawyers will say, why should I test that? I better not join the St. Thomas More Society. It's just a lot safer, because we have these ethics opinions all the time that just say various things are improper. This is the Great Wall of China. It is an architectural masterpiece. When Marco Polo first saw it in around 1200 AD, it was already 1,000 years old. This is a California case. Everything happens in California. The individuals said they had built Chinese walls as a barrier between the conflicted lawyer and the rest of the firm. And the judge said he thought that was linguistic discrimination. Well, what we know now, before that judge, don't refer to that. If those of you involved in securities law know that they say that they talk about Chinese walls all the time. For conflicts, we talk about screen. Because we don't want to say a wall. Some people think it's a tout to the engineering ability of a civilization that was so advanced when Western Europe was running around on bearskins. But now it's not enough that the judge says, don't do it before me. Anybody can now report that guy to the bar, and you can be disciplined, disbarred even. There. Let me see if we can. So now I leave. When vaudeville died, I went into teaching.
Thank you, Professor Rotunda, Professor Gillers. The floor is yours.
Thank you. Thank you for inviting me to address this important issue for our profession. It always has been, and perhaps it is especially so today. Everything I say today can be footnoted. It is footnoted in an article that is among your materials, and if you're interested in pursuing the legal issues and the legal history and the case authority, it's free. I can add to Justice Anderson's list of states that have addressed this issue. Earlier this week, the Tennessee Bar Association, in a joint petition with the Tennessee Disciplinary Council, asked the Supreme Court of the state to adopt 8.4G as written. There were proposals to add a few words to the comments to ensure that the First Amendment rights of lawyers are honored, but the proposal was to adopt the rule as written. Now, what I'm going to do is pose a series of questions which I would encourage you to try to answer in your own minds. And then if you answer them one way, you don't have to go on to the next question, otherwise you do. Jason S. called his female opponent a bitch, told her to go home and have babies, referred to her with anatomical references below the waist. You are a C, you are an A. Thomas M. mimicked and ridiculed the accent of an African-American woman opponent. Judge Michael Mukasey, later the Attorney General, a member of your board of directors, called his conduct race-based abuse, called it outrageous, and fined him. Later, the New York State courts disciplined him after making an independent review of his conduct. Robert K. would offer female lawyers, quote, peppermint ball candies and ask, quote, would you like to suck on one of my balls? And if they took offense, he would say, if you're so innocent, how do you know what that means? Henry M. leveled, quote, verbal assaults and sexist, racial, and ethnic insults against his Hispanic female opponent, told her to go back to Puerto Rico and that law is not practiced under girls' rules, quotes. All were disciplined. Now, the first question I would ask you to answer is, was that discipline wrong? Did these lawyers have a First Amendment right to say what they said? If you think they do, then you need not go any further, and we can have a separate discussion about that. If you think they do not have a First Amendment right to say what they said, then the next question is, do you think we should have a rule that forbids it? That is, you may think they do not have a right to say it, and yet you may say we should not nonetheless have a rule. If you believe we should have a rule that could lead to the discipline of these lawyers, then you must agree, of course, that that rule should give notice of what is forbidden. That is a due process obligation. And then the next question, if you've come this far, then it seems as a matter of responsibility, if you think this conduct can be disciplined, and that as a matter of due process, we need a rule that could impose discipline based on notice, then the next question is, what should that rule say? What should it say? Now, there are 25 American jurisdictions that have in their black letter rules prohibitions against bias or discrimination, or sometimes bias or prejudice and harassment. 25 American jurisdictions have this in their black letter rules, although the ABA until last year had it only in a comment. Among those jurisdictions is Minnesota and Texas. If you look at all of the jurisdictional rules together, you'll see that some are more demanding, some are less demanding. In my own research, Indiana is the most demanding. Indiana is the most demanding. That is, its rule nearly duplicates Rule 8.4G. If you look at the Code of Judicial Conduct, adopted in every American jurisdiction, judges are instructed to prevent lawyers from engaging in certain harassing or biased conduct based on a whole list of characteristics that are a longer list than the one in 8.4G, and a non-exclusive list, including, but not limited to, the following characteristics. Now, that rule applies in matters before a tribunal, but are we to say that this conduct is forbidden in matters before a tribunal, but it is allowed for transactional lawyers? They may call their opposing client a bitch and use anatomical references so long as they're not before a tribunal. You may think that 8.4G doesn't get it quite right. It can be improved. And yes, it can be improved. I have suggestions about how to improve it in my article. I think the Minnesota rule is an improvement insofar as instead of referring to socioeconomic status, refers to public assistance. I think that's an improvement. I wish I had known about that a year and a half ago. Socioeconomic status is nonetheless ubiquitous among the American states and in the Code of Judicial Conduct. Well, what about the First Amendment? Is it possible that someone will be charged with a disciplinary violation and will have an as-applied defense to that charge? That is, the rule may be okay, but my conduct is protected by the First Amendment, my conduct. Yes, it is possible. Now, you have to imagine in that situation, which is at the margins of the bad conduct, that a disciplinary counsel already burdened prosecuting people for stealing money and lying to courts will bother to prosecute that person. But if he or she does, there will be an as-applied First Amendment defense. We have today a rule limiting what you may say about a judge's integrity. That's a pure speech rule about a public official. Could not have that rule about an elected official. And on rare occasion, courts have said that a lawyer who has criticized a judge's integrity and has been cited under this rule, that lawyer has an as-applied defense under the First Amendment. You cannot punish that lawyer. But never has the rule been struck down. Indeed, I should say that none of the 25 rules in American jurisdictions has been found invalid. Indeed, I would go further and say that it is impossible to call 8.4G facially invalid without calling all 25 American jurisdictional rules facially invalid as well. Now, you may say, well, I can imagine situations in which the rule could not be applied. Yes, you can, and so can I, because we're lawyers, and that's what we are paid to do. But a state Supreme Court said that a statute will not be invalidated for overbreadth because it is possible to imagine some unconstitutional applications. That state Supreme Court was from Texas. You can imagine that the rule will be challenged not only for overbreadth, but also for vagueness. Well, a Fifth Circuit decision confronting a challenge to a rule forbidding conduct prejudicial to the administration of justice, a rule that is pervasive in American jurisdictions, pervasive, and certainly gives less notice than does 8.4G. The Fifth Circuit said, in a case from Texas, because it was construing a Texas rule, the rule, quote, applies only to lawyers who are professional and have the benefit of guidance by case law, court rules, and the law of the legal profession. Now, I want to shift to a different tempo. people are telling us, people who are the victims of this conduct, the diversity committees of the ABA, the committees concerned with sexual orientation, racism, rights of women, disability rights, those committees weighed in and said, we need this. We need this. The proponents of these rules, the opponents of 8.4G, save only for the First Amendment free exercise opponents, we can come to that, have been overwhelmingly white men. The proponents of 8.4G have been overwhelmingly persons concerned with discrimination and bias, including of members of their own groups, in the practice of law. Now, we have two choices, and when I say we, I mean the opponents. We could try to take pot shots at 8.4G by saying factually and legally incorrectly that it is a speech code for lawyers, which is a lie. We could say that and try to shoot it down with those kinds of arguments, or we can be constructive. We could listen to the pain of the people who say, this hurts me. This hurts me every day I go to work. I have been the victim of this behavior, and I need my courts to protect me, and we could try to provide an appropriate rule to protect them. You may not like 8.4G. As I say, I could play with it, and I think I can improve it. I think Minnesota has improved it in the manner I said. But you have really two choices. We, as the profession, have two choices. Either we constructively try to improve it, or we denigrate it in ways that are so remote and hyperbolic that they do not deserve our close attention and credibility. Thank you.
Thank you, Professor. Mr. Paxton.
Well, great to be here. This is my first opportunity ever to speak to on a panel at the Federalist Society. You know, looking out in the audience, I don't usually get an opportunity like this where I find somebody in the audience that I went to college with that I could actually embarrass. So since I have that opportunity, Don Willett and I were actually at Baylor. Don, just raise your hand. So Don is, if you don't know, he's trying to move from the Texas Supreme Court, our highest court, to the Fifth Circuit. I don't know, do you all know what that's called in Texas? Downwardly mobile. I don't know if Don knows this, but I don't know what it says about us, but while we were there, we also had in our midst the guy that is the first Republican Speaker of the Mississippi House, Philip Gunn. We also had a congressman named Trey Gowdy and a senator named Rand Paul. Now, don't let that scare you, but it is an interesting mix of people that were all at Baylor at the same time. You know, my grandfather was an immigrant and 8th grade education, and he moved here to have a better life. He was a coal miner, and he certainly had some discriminatory views. And I learned about this growing up, and I would say he despised certain groups. I would say even hated certain groups, and I'll tell you what the two groups were. The first was lawyers. And so I went to the University of Virginia, and after I was about to graduate, went down to visit him in Florida. I said, now, Grandpa, I know you don't like lawyers, and you know I'm going to be a lawyer. And he said, yeah, you're going to be the only honest lawyer in America. And then there was a second group that, unfortunately, he passed away, that I never got to really talk to him much about, and that was politicians. And I obviously am in that group as well. As a matter of fact, growing up around him, I never heard the word politician as a standalone word. It was always preceded by the word jackass. So I stand, I guess, in both of those categories. I was going to tell you real quickly, it's kind of interesting that I'm here because I was going to tell you about my worst grades in undergrad were, oddly enough, undergrad class of political science was my absolute worst grade. And then when I was in graduate school, my worst grade was in statistics, and it really wasn't so much for my performance. I actually asked this question that I think affected my grade, which was, the statistics professor was talking about sample size, that any sample size under 30 wasn't a valid sample. So I raised my hand and I said, Professor, we have a midterm and a final that's 2. Is that a sufficient sample size for you to judge our behavior? I think that affected my grade. And then in law school, I took a property class. It was my first year in law school. I literally, this was a Yale professor. He was a little, I thought, wacky. I never really connected to what he was saying, and I didn't make that good of a grade. And then, oddly enough, smart as I am, I took him again my third year. And the way the class started off, my third year, you might wonder why would I take him again when it was my worst grade in law school. The way the first day started off, he says, "Look, if you're a third year," he said, "I'm going to tell you ahead of time, we have one final, and you can put on the top of your page that you're a third year and you want a B, and you'll get a B. Now, if you want to go for an A, you might get a C." And he said, "Now, I realize for some of you, this is the last time I'm going to see you until the final." And that was actually true for me. So I realize that some of you are getting ethics credit, and you might not be here but for the ethics credit, but I do think we do have an interesting topic today to talk about. For me, I came into this issue a little differently. I have a job as Attorney General. We issue opinions, and we issue opinions that are requested by legislators, typically committee chairs in the Senate and House, or state agency heads. And so I was asked by one of my legislators, Senator Perry. He was concerned that if the rule were adopted, this rule, by the state of Texas, by the bar, lawyers could lose their licenses for being part of bar associations or other legal organizations that oppose same-sex marriage or fight federal guidance on transgender bathrooms. In a letter, the senator expressed worry about the rule change means religious lawyers may be targeted, and this is his quote, targeted for elimination from the legal profession. In my advisory opinion, which we respond to, we're required by the Constitution to respond to questions that are asked like this, and the general goal of our response is to help avoid litigation. And obviously, it's not binding on any court, but it is our effort to make the best effort at trying to help people understand what the law is. In my advisory opinion, we wrote that if the state of Texas adopted 8.4, a court would likely strike it down as unconstitutional for being overbroad and vague. The provision in Rule 8.4 could restrict an attorney's religious liberty and prevent him or her from wholeheartedly representing faith-based groups, one of our concerns. The amendments to the ABA's Rule 8.4 subjects attorneys to professional discipline if they engage in harassing or discriminatory conduct on the basis of race, religion, natural origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic and this is the key words, connection with conduct related to the practice of law, which was already mentioned. In fact, the Texas Bar already has rules, so we've already addressed this rule, and I think you mentioned that already. We addressed it very closely, and I stated in my opinion that Rule 8.4 change opens the door to punish lawyers who express views contrary to the state bar with regard to religion, sexual orientation, and gender identity. A court would likely conclude, we said, that the ABA ethics rule would infringe on one state bar member's free speech, free exercise of religion, and freedom of association. The rule could be broadly enforced against lawyers participating in continuing legal education panels, discussions, or just having an informal conversation at a bar association event. As I wrote in my opinion, I'll quote it here, in the same way, candid dialogues about illegal immigration, same-sex marriage, or restrictions on bathroom usage will likely involve discussions about national origin, sexual orientation, and gender identity. Rule 8.4 would subject many participants in such dialogue to discipline, and it will therefore suppress thoughtful and complete exchanges about these complex issues. Another concern I voiced in my opinion is that application of Rule 8.4 in Texas would discourage attorneys who hold certain religious beliefs from taking on cases for fear of being disciplined. The Supreme Court has ruled that attorneys' free speech rights are somewhat restricted in and outside the courtroom when speaking about a pending case. But the change to Rule 8.4 extends far beyond the context of a judicial proceeding to restrict speech or conduct in any instance when it is related to the practice of law. In other words, it could extend to attorneys' association with certain groups, including certain faith-based legal organizations. And I think it's interesting and maybe instructive that the bar stepped into and filed a brief in a case in Florida where the state restricted speech of doctors as it related to talking to their patients about gun ownership and restricted it to basically only if it's medically necessary to talk about. And let me read you the last paragraph before the conclusion. And this was written by the ABA. And here it is. Indeed, if the state were permitted to do what it has done here, the consequences would be far-reaching. With only the most tenuous pretext, the government could intervene into any professional-client relationship and manipulate that relationship to further the government's agenda and suppress opposing viewpoints. That would not only constitute a gross infringement on the professional's right to speak and the client's right to listen, damaging the professional's ability to effectively serve the client's needs, but would also impermissibly distort the broader marketplace of ideas. This court should hold the states cannot engage in such viewpoint discrimination simply because a speaker is a doctor talking to his patient or a lawyer talking to her client. I think it's very applicable to this same rule. Thanks.
All right, we're going to take a few minutes here and have a little exchange between our members about the various comments that have been made. Who'd like to go first?
Sure.
President Brown?
I keep seeing everybody looking at me, so I guess I'm going first. You know, there are a couple of things. You know, I listened to some of the examples cited by Professor Rotunda and also by Attorney General Paxton, and I think that they are not good examples. So, for example, Attorney General Paxton just indicated that if a person is at a gathering or a bar association meeting and there's some discussion about a particular issue, then that attorney can be found in violation of 8.4G. The rule specifically states that that is not the case. The rule talks about harassing individuals or people who are generally legally in a protected group. It does not apply to debate about a particular subject matter. The rule is very clear in that regard, and also the anecdotal evidence has shown that their cases are not brought for those particular reasons. They're brought for the reasons such as those cited by Professor Gillis when a person engages in conduct against another person, not with respect to a discussion voicing your opinion about a particular group or particular organization. The other thing is that, you know, it's really clear about representation, that you don't take on the opinion of your client or the position of your client because you make a determination to represent that client. There's nothing in the rule that causes you to engage in zealous advocacy on behalf of your client. The rule is just really clear. And so the examples that are given, unfortunately, I think that they are made to invoke fear in some people, that you won't be able to do things that you would normally do or engage in the type of free speech offer opinions that you usually do. That is not what this rule does. And I think that if we really read it carefully, we will come to understand that. I also think that we can't compare someone who owns a bakery with lawyers. So because someone owns a bakery and they are prohibited from doing things, they're not lawyers. And I think that when we start to compare apples and oranges as against each other, as opposed to giving real life examples of legitimate things, then that could cause the waters to be muddied and for us to engage and go down a rabbit hole that we may not necessarily want to go down.
Professor Rotunda, and then I think Attorney General Paxton.
Yeah, can you all hear me with this? Yeah, all right. A couple of things. I know Steve said it's basically white males that oppose this. It makes me feel deplorable when he says something like that. He said that there's already 25 states that do that. I think that's not a fair review of the law. If you look at it, in fact, Bill Hodes, who's I don't think is here today, but a professor in practice in Florida, he said Florida was included in that list. He looked it up, but he didn't find anything that was similar to 4.8G. In every example that Steve gave, the lawyers were disciplined. What you do in front of court, what you do in deposition is like being in court. We can judges can make you wear a tie if they want. And maybe that's too much power, but it's not part of 8.4G. That's already taken care of. In fact, since all these people were disciplined, why do we need this vague rule? Paulette says that you don't take on, this is a face-to-face type encounter. But we saw from the example of wearing the "Don't Tread on Me" hat, the guy just wore a hat. He didn't wear it to shove it at somebody, just wore it. Somebody else said, oh, I think that's racist. He didn't know that. And the EEOC opens up a full-fledged investigation, and the employer's got to defend that. There is a difference. You get a lot more due process before the EEOC than you ever will get before a bar disciplinary committee. And then we're told if there's objections, have an as-applied challenge to the First Amendment. Like Deborah Rohde said, trust us. Steve said, the bar has too many things to do to go after an unpopular lawyer if they want to pin something on them. It reminds me of the three jokes of the 20th century and the three jokes of the 21st. In the 20th century is I'll love you just as much in the morning, the check's in the mail, and I'm from the government and here to help you. And the three jokes of the 21st century, this is just a cold sore, my Maserati is paid for, and I'm from the government and here to help you. You see, some things never change. Some things never change, and what we're supposed to do is rely on the goodwill of the bar administrator, and we could always make a First Amendment challenge. So if the local bar says, for example, that it is discriminatory to join the St. Thomas More Society, we can always fight that, or we can take the easier way out and not join. And that's what this rule invites. I think when lawyers draft rules governing the practice of law, they should be a lot clearer than what we've got here.
Attorney General Paxton?
So let me read the language again. Engage in contact that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, and then all the other factors in conduct related to the practice of law. In my opinion, very vague. We know if this is passed across the country, we aren't going to be talking about this rule much. We're going to be talking about the cases that it's affecting. Just like for my state, we filed an amicus brief in the case, the Masterpiece case that involves a photography, somebody that didn't want to participate in a same-sex marriage, and now they've been punished, and it's going all the way to the U.S. Supreme Court. Or Arlene Flowers, which we've also filed an amicus brief. Those are rules similar to this, and of course, I'm sure when they were passed, they were told that it wouldn't affect free speech, but clearly, in both of those cases, going to the U.S. Supreme Court, it does. And I have no doubt that it's nice to say that this wouldn't affect people's speech and their religious viewpoints, but we all know that it ultimately would, and we'd be talking about cases, and we'd be signing on to cases going to the U.S. Supreme Court, just like with Arlene Flowers and Masterpiece, just like this.
Professor, anything?
Well, Professor Rotunda talked about notice. And notice is important. 8.4G gives more notice than many of the rules now present in American states. More notice. Michael Mukasey fined Thomas M. using this rule: a lawyer shall not engage in offensive personality. Offensive personality was his basis. Does that give adequate notice? I think not. The Ninth Circuit thought not. Because in a case in the Ninth Circuit where the lawyer's sexist conduct, the court said, could be disciplined, the court said that he could not be disciplined based on a rule forbidding offensive personality. So if we're interested in notice, and we know we're dealing with not a general population, but we're dealing with lawyers, and we have that Fifth Circuit precedent saying you have to look at who is being given notice, isn't it better to be clearer, to be more specific? What can be the argument against that than to be vague, than to use a rule like prejudicial to the administration of justice? Does that give more notice than the rule that is before you?
So we can begin lining up if you have questions. I do have one question that I'd like to direct to Professor Rotunda or Mr. Paxton, and two speakers who are skeptical of this rule, and that is, should there be such a rule in the first place? And then in the second place, if there should be such a rule, would you favor language that is different than the ABA? If we were in my courtroom, I'd pick on one of them, but do you guys want to volunteer or
Well,
just take a run at it?
Yeah, I think the rules should be there because they have a functional relationship to the practice of law. So we have cases saying that failure to file income tax doesn't mean you're disciplined. Filing a false one would, because that is misleading, and somebody engages in fraud or misleading conduct relates to the function of law. The ABA rules now say, they used to say moral turpitude, and they say, no, if you can do a lot of bad things as a human being, adultery is one of them, but they don't have a functional relationship to the practice of law. Committing adultery with the client involved in a divorce would, and you get disciplined for that. So I think, first of all, the rules should have a functional relationship to the practice of law. The purpose of this rule, said the reporter's notes, is to change our way of thinking about things. And frankly, that sounds very Stalinistic to me. We want to create the new Soviet man that thinks about things differently. By the way, I think we should change our views about a lot of things, but I think we use persuasion to do that and not discipline. We just educate people. And if we were to have such a rule, I would make it a lot clearer. I would explain, for example, why is it that you get a free pass on a racist peremptory challenge? That's not important enough for the ABA. That actually is right there in court and does have a functional relationship to the practice of law. So if they could explain this, if they could explain, Paulette said it covers more like face-to-face conduct. Well, then the rule ought to say that. Instead, it says it covers bar associations, business, or social activities in connection with the practice of law. So I'm dubious about this rule. If we think that it's necessary, it ought to be drafted a lot clearer, and we ought to explain why you get a free pass for a peremptory challenge, a racist peremptory challenge.
Mr. Paxton, any thoughts?
So no, I actually agree with the professor. He hit it on the head, and our rule is narrowly defined, more related to the practice of law, and I want to read it. It says, a lawyer shall not willfully, comma, in connection with an adjudicatory proceeding, comma, except as provided in paragraph B, manifest by words of or conduct bias or prejudice based on race, color, national origin, religion, disability, age, sex, or sexual orientation towards any person involved in that proceeding in any capacity. So it hits exactly his point. It ought to be based on the practice of law.
Professor Gillers or President Brown, any thoughts on that, or should we move to questions?
No, I have a couple of thoughts. One, I want to correct the record that I did not say that it had to be face-to-face conduct.
Misunderstood. Sorry.
That's a mischaracterization. What I said is that the conduct is directed to individuals. And I think that we have to be real clear about preemptory challenges. It's not that it can't be deemed to be a violation. It is not. It is just that it is not the only factor, that you look at the totality of the situation. So I think that we have to be really careful about parsing out and taking things out of context. And I also think that we also have to think about, when we talk about engaged in the practice of law, we think about those holiday parties that lawyers have notoriously been known to have, and whether it is okay, even though it's not in a judicial proceeding, whether it's okay for people to engage in sexually harassing conduct at a party sponsored by a law firm, for a partner to sexually harass a female associate. Is that okay? I would submit that most right-thinking people would say that no, that is not okay, and that there should be some disciplinary action available to handle that.
Professor, anything further? Should we move to questions?
I just
very quickly.
Yeah, well, just one final point on the overbreadth doctrine. I'm surprised at the suggestion that this could be struck down as overbroad. I think we would have to change First Amendment jurisprudence to do that. Consider this quote. There comes a point in which the chilling effect of an overbroad law, significant though it may be, cannot justify prohibiting all enforcement of that law, particularly a law that reflects legitimate state interests in maintaining comprehensive controls over harmful, constitutionally unprotected conduct. That is a unanimous Supreme Court opinion written by Justice Scalia.
Let's start here. Microphone, tell us who you are and your question.
Okay, my name is Aaron King. I'm a student with the University of Michigan. So forgive my ignorance if the question sounds ignorant. But I was wondering if you guys could comment on the difference in the standard between the prior comment that was knowingly versus the new, which is reasonably should know. So it seems like it's taken from a knowing standard to a negligent standard. And negligent discrimination seems like an oxymoron because discrimination is intentful. And reasonably should know makes it sound like the disciplinary board would only need to show that somebody else would think that it's offensive, not that it was intended to be offensive.
I think that was the purpose of the change in the language. I think that's right? To make it easier to bring these charges and prove them.
So originally, the knowingly part was not there?
No, it was there.
No?
It was in the
No, no.
comment. It's,
yeah.
it said knowingly.
Right, so, but the language was, it's been modified several times over the course of all of the discussions. So there was language that made it, if for lack of a better term, made it a little less difficult for a prosecuting agency or disciplinary prosecutor to prove the language. And so stronger language was put in as somewhat of a protection to lawyers and the level of knowledge that they had to have in order to be charged with an ethics violation.
Yeah,
Professor Rendon,
here's the actual language, that this is before 2016. This is in the comment. In the course where it's inclined, a lawyer should not knowingly manifest bias.
Right.
And they changed knowingly to reasonably know to make it easier to prove the case.
Over here, question?
Yes, good afternoon. Gregory Dolan. I teach law at the University of Baltimore. Perhaps I should preface the comment by admitting that I am a former Soviet citizen. So, but luckily not for too long, so perhaps I didn't quite manage to change my mind. But here's my question. I teach torts, and we have in tort law a standard saying at some point, including verbal things, rise to the point that gives tort liability, intentional infliction of emotional distress. And it seems to me that what Professor Gillis was describing with those comments are that rise to that level, that being outrageous, that somebody should not tolerate in a decent society. Although I guess I would ask also, how do we square it with the fact that our society has become coarser, where the comment, and I apologize for repeating it, but when the comment "suck my balls," right, is a popular tag phrase on a very popular TV show, right? Eric Cartman does it all the time on South Park. And so when our society has become that coarse, not that we should necessarily use it in a courtroom, but why not just say, look, we're going to measure it not what somebody at any given moment finds offensive, but say, look, we have the standard. When it becomes outrageous, judges, bar counsel, disciplinary committees can punish without necessarily having these new rules that are somewhat vague and potentially limit people's ability to join societies.
Professor Gillers?
So do you prefer as adequate notice prejudicial to the administration of justice, or offensive personality, or something like that?
I think, if you ask me, ultimately, if the standard ultimately seems to correspond to something like IIED, it's not the question of how the rule is phrased, it's how the rule is, enforced. Just like IIED is not really a standard, but we know what it means.
Yeah, look, prejudicial to administration of justice is frankly way too vague for my taste to take away somebody's livelihood. But if you look at the cases brought under that, where lawyers are actually disciplined, you find out they did something else bad that was within the rule, and the bar disciplinary authorities, I guess, throwing in the kitchen sink approach, threw that one in as well. I'm not going to say it doesn't exist, but I've never found a case where it was just prejudicial to the administration of justice. But in any event, to the extent these rules are vague, they should be made clearer, not more vague. If we're really serious about what's going on, if this is not just law day talk to have the general public think, look, we're doing something, we don't really mean it that seriously. It ought to be a lot clearer. And I say the only case I found where something bad that was already in the rules plus prejudicial to the administration of justice. The guy knew he was bribing a juror, things like that.
I just want to say, so you're from Russia?
If Putin has his way, yes, but Ukraine.
Ukraine, okay. So I'll just say to you, first of all, please stay away from Jeff Sessions, and and then I'll say Zdravstvuyte, товарищ, как вы позволите?
Over here.
Scott Univer, New York Lawyers Chapter. We're all lawyers here, or almost all, and so we like to solve problems with rules. The problem with rules in this kind of situation, I think, is the more specific they get, the more interstices you create. The examples that Professor Giller cited are real, and they're serious, and they cause actual injury and hurt, and I don't mean to minimize them. But would we be better off, this is my question to the panel, would we be better off going in 180 degrees in the other direction and adopting a rule that says only lawyers shall treat all participants in the legal process with dignity, courtesy, and respect, period?
Is that anybody? Yeah,
You-
if
you
you'd like to
know-
give all this power to disciplinary people, then that would be what you do. And if you'd like to disbar lawyers or refuse to admit them because they engage in unpopular activities, that's what you do. We had all this unfortunate examples in the 1950s and 60s, both with the McCarthy era followed by the Vietnam War protests, where the ABA, sadly, was not in the vanguard in protecting free speech. And it seems like every generation has to learn and relearn what the prior generation learns. And everyone says, oh, this time it's different. I think when lawyers engage in this racist, sexist comment, we shun them, we make fun of them. Most people would not want to patronize lawyers like that. In that sense, I think the general market, I think, is fine to publicize what they've done. But once you have a vague rule, you're asking for trouble, particularly since, the tort of intentional infliction of emotional distress has all kinds of safeguards into it because the courts were worried when they created it would be excessive. This has none of the safeguards you get in ordinary tort where all you could lose is some money. Here you lose your license to practice law. You lose your livelihood.
Professor Gillers?
About 25 years ago, the profession was all about writing codes of civility and codes of professionalism. And many state bars generated codes of civility. The ones I'm familiar with always began by saying, nothing in this code shall be a basis for discipline or civil liability and cannot be cited in any forum. And they had language like dignity and respect. Personally, I'd rather have 8.4G. I think if we had dignity and respect, we'd generate a jurisprudence that mimicked 8.4G anyway across the following 20 years. But the reason I want 8.4G is independent of everything else. It's a statement about who the American legal profession is. It is a statement we are making to the public. It is a statement we are making to ourselves, to our law students. Just having it there is important, independent of its use, though I do believe that its use will be and can be, as the use of all 25 other rules in existence today can be and have been used appropriately.
Yes, sir.
Pepper Crutcher, an employment lawyer like you from Mississippi. President Brown, my question is for you. Suppose that I am the managing partner of a very large law firm that recruits from only the top law schools and only the law review members from those top law schools. And as a result, my entering class of new associates every year has the look of the typical big law entering class of associates every year. In that context, what is the difference between the negligent discrimination standard of Rule 8.4G and the disparate impact standard of hiring cases under EEO laws, if any?
So the rule says that you cannot harass or discriminate. And I think that we should focus on those two words, harass or discriminate. Where you choose to recruit does not constitute harassment. If you choose to recruit only in certain places, law firms are not prohibited from doing that. That is not discrimination on its face or otherwise. It's where you choose, it's the same notion as if you choose to go to Mount Holyoke Baptist Church as opposed to Thomas More's Catholic Church. That is not discriminatory conduct under 8.4.
So you would support, for example, a comment that said this does not adopt disparate impact model proof for negligent discrimination?
So, or I think that it's bad for your law firm for you to do that, but it is not discriminatory conduct for you to recruit only at certain schools.
The comment 4 says this covers operating or managing a law firm. So it would cover who you hire and who you fire. Then says you can hire and fire, that you can do things to promote diversity and inclusion without violating the rule. I guess recruiting the top law schools, no one has ever thought about that as being inclusive and diverse. So it can raise it. And then when it says know or should know, or reasonably should know, well, in all the other law, we do look at disparate impact. And then you think of the messenger who you don't hire, and he sues you because you didn't hire me because you're transgender, you don't have a unisex bathroom. That's not why I did it. It's not against the law in my state anyway, but, well, I think it is. You've got a cause of action as well as a complaint before the bar, and then you hope that the bar will exercise discretion not to prosecute you. And if you're a big white shoe law firm, they won't. And if you're a little bit of a prickly dingo who represents clients that other people don't like, they can always open up a charge.
Any other comments on that question? If not, over here.
I think that we can find ghosts in every closet.
Okay, over here.
Hello, my name is Patrick Silloway, and I have a question about how harassment is defined and how the, putative harmed person can define harassment. I had a hypothetical of a law student goes in for an interview with a law firm, and the law student is, dressed like I am, but they go in and they say, I prefer to be called G, to be referred to with non-binary gender pronouns. If the partner conducting the interview uses he or she, does that violate Rule 8.4G?
The comment 3 tells us that the fact that it does not violate a substantive anti-discrimination or anti-harassment statute doesn't mean that it does not violate this rule. So yeah, I can create all kinds of complaints that even if the lawyer is ultimately vindicated, is going to cost them bad publicity and money. And that's one of the real harms.
And it also depends on whether the chief disciplinary officer of the state, they have a lot of discretion as to what kind of claims they will actually bring against an attorney.
And I just say, yeah.
What?
Attorney General Paxton.
Yeah, I just say quickly, those are exactly the types of issues that are going to get litigated if we have this rule.
I didn't hear what you said, I'm sorry.
Exactly the type of issues that are going to get litigated as soon as this rule is adopted.
I disagree. There's no evidence that shows that there's an increase in litigation.
Next question. Yes, sir.
Richard Samp with the Washington Legal Foundation. I very recently read Justice Sotomayor's autobiography, and she talked about a case where she thought that she had been racially harassed in law school. And I was aware of that case because I was working at the law firm where the partner who supposedly harassed her was asking questions at a dinner with many people where he basically said, look, our law firm is being encouraged to diversify, to engage in affirmative action, but one of the things we found is that we've hired several minority people and with lower grades and LSAT scores with the hope of diversifying, and then we had to let them go after 2 years. Isn't it better perhaps not to engage in affirmative action? She filed a complaint with Yale Law School. My law firm and this partner were disciplined by Yale Law School. She wrote about this in her autobiography. I'm just wondering, I gather that the point of this rule is to give increased protections, move the bar a little bit for on the issue of harassment for protected groups. I'd be curious as to what you would think about a law school interviewer at a dinner with a number of people asking questions of that sort, whether that violates the rule.
I think it's a fine question and can have a great conversation, and I encourage discussion about these issues. I think it's beneficial to law students and beneficial to the interviewer to have that discussion. On the other hand, I think if a law firm took a position, you know, we're not going to hire any more Hispanic associates because the retention rate is so bad as a class. And so we're going to reject any application from an Hispanic person, or perhaps an Hispanic male or Hispanic female, not because of anything about that person, but because he or she is a member of a group where we have had bad experience in our hiring. I think that would violate the rule.
I mean, to clarify, this partner had called back Sotomayor to a dinner because he thought she was an excellent applicant and was asking this question, and the complaint was not that she was not hired. She was, I think, would have been offered, but rather that you shouldn't ask questions like this.
Well, look, none of us was at that dinner, and I haven't read the book. So I can think of situations in which I would think that conversation would be beneficial. Maybe this was such a situation, and maybe she's overreacting. On the other hand, maybe it's not. So obviously, the content of the discussion is important. So I might disagree with her, and if I did, I would not ban that law firm from interviewing at my law school.
Next question over here.
Good afternoon. My name is Tim Corshane. I'm a Marine Judge Advocate right now. My question is about being a lawyer, right? We all had a life prior to coming into law. I find it unrealistic to believe that these rules like this would not be used in determinations of character and fitness to becoming a lawyer. First question is, what prevents counsels or whoever makes the determination on character or fitness from using considerations like this about stances people, students, advocates in previous lives, using that against them in determinations of character and fitness? And then secondly, does that not also create a chilling effect of entry into the legal profession for people who may have taken stances, taken actions prior to coming into the legal profession that may violate 8.4?
That it's a risk. There's no doubt about it. And while the cases purport to say that the standard for not admitting you is the same as the standard for excluding you, in practice, it is a lot easier to exclude and a lot harder for the applicant to get admitted if they've decided under character and fitness that there's a problem. Sometimes it goes back years. We live in an interesting world.
And it's not just regarding 8.4, it's regarding any type of issue that affects the potential lawyer's character. It's not limited to 8.4.
So does this not also give them an extra ammunition against applicants like that?
Oh, yeah.
I wouldn't characterize it as ammunition. I would characterize it as compliance and not engaging in inappropriate conduct. Not ammunition. If you don't engage in inappropriate conduct, then it can't be deemed as ammunition.
Next question over here.
Good afternoon. My name is Connor Mile. I'm a student at the University of Alabama School of Law. This question is directed primarily to Attorney General Paxton, but I'd also love to hear input from anyone else on the panel. Attorney General Paxton, we actually covered your opinion on this matter recently in my legal profession course at the University of Alabama, and we discussed how many proponents of 8.4G consider it reflective of an aspiration that lawyers should be beyond reproach, especially regarding harassment of what the ABA would consider protected groups, as Ms. Brown mentioned. Would the problem of the chill against free speech and free expression that's pretended by the rule that you mentioned possibly be abridged by adopting 8.4G's language as a comment to the rules as opposed to an actual rule, as the comments are considered generally more aspirational and clarifying of the actual rules rather than binding language. Would that be an acceptable compromise between the two
It
positions?
would still concern me because it's the same language, it would be used in the same way, and these cases that I've talked about would exist with lawyers around the country, and we'd be battling this for years, and we'd have panel discussions about each case. I don't think it would change anything.
Anything else? Next question.
Hi, good afternoon. My name is Ashley Terrazas. I'm a 3L at the University of Texas. Welcome. I have two questions, actually. The first one might be pretty easy to answer. On the face of it, it doesn't seem like the rule... I understand the concerns about religious liberty with the rule. Is there a comment or something that makes it clear that a religious lawyer is free to not take certain cases?
There is,
Yeah.
well,
Okay.
you go first.
The comment very clearly states that a lawyer is not prohibited from accepting or declining a particular case.
Yeah, the rule says you retain your rights under Rule 1.16 to decline a case. 1.16 doesn't give you a right to decline. The old model code, which goes back to 1970, it said, we're not like taxi cabs. You don't have to take the next client that comes through the door. There is no such provision under the present rules. And there's the New York opinion that says, you don't have that right, and they give the example of the Mormon. So that's a problem. I gave the example of the lawyer that says, I think you demean women by doing, wife number 5 and 4 and so on. But you could have a religious thing. I don't want to take your case. I don't want to sue my pastor. I don't want to sue my church. And because of their stance on gay marriage, that's the topic right now. My own personal view is they ought to get married and suffer like the rest of us. But and under the rule, you can do that because 1.6 says you have the right to reject in accordance with Rule 1.16. 1.16 says you can reject if they don't pay. Lawyers are good about that. And you can reject, you can withdraw if they don't pay. You can withdraw because you must withdraw if continuing representation will involve you in violation of the law. But nothing says you don't have to take a case because you don't feel like taking the case.
So we have about 1 minute left, and I'm going to ask the gentleman behind you there, I'm going to give him the last opportunity.
Thank you. The title of the presentation is Using the Licensing Power of the Administrative State in Relation to this new rule. We haven't talked about this as a situation similar to the hair braiders and the undertakers whose licensing is being challenged all over the place as state-supported cartelization. And I ask the entire panel, isn't this just one more way that we limit entry and retention in the profession using state power? And do we really need to do that now that every other kind of professional licensing is under challenge?
You don't have to get an MBA to practice business, but you got to get the JD and get admitted to the bar to practice law. There was a case, about 2 years ago, involving teeth whitening by dental examiners, something like that, a Supreme Court case, and they invalidated the restriction on antitrust grounds. And then Justice Kennedy had a gratuitous cite to my book, which made the same point. So this, I think that when it comes to things like unauthorized practice and so on, that the bars they have risks going forward with respect to that.
10 seconds left. Anybody else want to respond further to that question? If not, thank you all very much.
Thank you, sir.
Thank our panel.